Welcome to today's session on personal planning. Today's session is for people who are living with dementia, people who are caring for someone living with dementia, and for all others as well, because it's important for all of us to get our healthcare, legal, and financial affairs in order. We're going to be taking a look at the following areas today. Because this is a short presentation, it will be a rather general overview. Today we will focus on personal planning. We'll start by defining what we mean by personal planning and the importance of early planning. We'll share some tips on how to start conversations around personal planning, and we'll review what personal planning looks like in BC and the legal tools available, and share resources with you. The diagram on this slide shows us the difference between estate planning and personal planning. Both are very important. Estate planning is planning for after you die. Most of us are very familiar with this planning, which involves making a will. Personal planning, however, is for what happens during your lifetime, and this type of planning may be less familiar. Our presentation today will focus on the two key documents required for personal planning, the enduring power of attorney and the representation agreement. Many of you will have heard of a power of attorney, but you may not be familiar with the representation agreement, which is equally important. Every adult in BC should have documents in place that appoint decision makers for healthcare, personal care, legal, and financial decisions. We all need these documents in the event that we can no longer make decisions for ourselves. Putting these documents in place early is beneficial because it reduces future stress and the potential for a crisis. Personal planning can be uncomfortable as it causes us to consider some sensitive life topics. We're considering decisions about the future that we may prefer to not think about. We all want to imagine ourselves healthy and capable in the future. However, if we can start these difficult conversations now, we can avoid distress in the future, whatever that future looks like. While the time to plan is now, recognize that it is a process. Personal planning can be overwhelming, and feeling overwhelmed can lead to procrastination and not getting anything done. Planning early is the preferred way to go because it is more likely that the person living with dementia can be part of the conversation. Having the person with dementia participate helps care partners and family members have the confidence to know that they will be able to honor and implement the person's wishes. This can also help to reduce the chances of future family disagreements. Our goal today is to help motivate you to start thinking about personal planning now and to learn where to get information and support so you can begin to arrange your planning documents. We do want to emphasize, though, that when necessary, please seek professional advice. I am not a personal planning professional, and this session is not meant to give legal advice. Another reason that it's important to start planning early is because many of these documents require mental capability or mental capacity, and this changes as dementia progresses. Because dementia progresses differently for everyone, it's difficult to predict how and when someone's capacity will change. However, by planning in advance, you can prepare to manage the future no matter what changes occur. Being incapable of making some decisions does not mean that a person is incapable of making all decisions. However, it can affect the type of legal documents that can be made. It's best that planning takes place while a person living with dementia can participate in decision making and has mental capacity to make legal and financial decisions. This gives the person living with dementia a sense of control over their future. Mental capacity is a legal term that refers to someone's ability to fully understand the meaning of what is being decided. It is not a medical test. It's up to the lawyer or notary to decide whether they believe the person is capable of signing a legal document. Because there is no standardized tool that is required, the decision regarding a person's capability can vary by lawyer or notary. The law will not recognize or enforce the decision of a person who is not mentally capable of understanding the nature and the consequences of that particular decision. There are two different personal planning paths for individuals in BC. The path of those who are planning for the future, that is, for people who are legally capable of understanding the nature and consequences of their planning decisions at the time that they are making those decisions. And there's the path of those who need help today, that is, for people later in the journey whose capability is already under question. We'll be discussing both paths, as well as the different legal tools that correspond with each. So the first personal planning path we'll discuss is for those who are planning for help in the future. This path is for adults who understand the nature and consequences of their planning documents at the time that they are making them. If you're on this path, there are two legal documents which cover all life areas: an enduring power of attorney and a representation agreement, Section 9. These two blocks are highlighted in red on this slide. Let's look at Miriam and Faisal. Miriam was diagnosed with dementia, but is still in the relatively early stage. She attends an early stage support group and is very aware of her own experience of living with dementia. She recognizes that things are changing, and she wants to make sure that when she is no longer able to make decisions for herself, she has put in place the plans that she wants. Miriam and Faisal decide to set up an enduring power of attorney and a representation agreement. The enduring power of attorney is a legal document that allows you to give legal authority to a trusted person or persons to manage your legal and financial affairs and make decisions on your behalf if you become mentally incapable. That is the enduring part. It does not cover health care or personal care decisions. We'll talk more about those areas next. In Miriam's case, she is still able to demonstrate her mental competence to the lawyer. She knows the year and the season, and she understands that she and her husband are meeting with the lawyer to set up documents to protect her future. The lawyer gives several examples of the value of an enduring power of attorney. For example, if they do not have an enduring power of attorney, Faisal will not be able to sell the car that they jointly own without Miriam's signature, and she may not be mentally capable to sign the documents at that time. The same is true of selling the family home. Because the home is owned jointly, it requires both owners to be signatories, and without an enduring power of attorney, it will not be possible for Faisal to sell their home. We strongly recommend consulting a lawyer or notary public for this document. And again, what is called legal competence is required in order to create an enduring power of attorney. The lawyer or notary will determine mental capacity. The second document for future planning is a representation agreement. This is a legal planning document that allows us to give someone we trust the legal authority to make healthcare and personal care decisions on our behalf if we become unable to make those decisions for ourselves. Most people appoint a spouse or a partner, a family member, or a close friend. Again, looking at Miriam and Faisal, if Miriam is no longer able to make decisions for herself, having a representation agreement in place will allow Faisal to consult with Miriam's doctor about her medications, medical treatments, and to make decisions about moving Miriam to long-term care. Miriam and Faisal have talked often about their wishes for the end of their lives, and so they choose to include a section on end-of-life decisions in their representation agreements. It's important to note that while Faisal is the person that Miriam appoints to be her representative and attorney from the previous slide, Faisal needs to find someone else to be his representative. Dementia is progressive, and Miriam will not be able to be his representative. Faisal would be wise to appoint another person now so he doesn't have to worry. One other point worth mentioning here is that in British Columbia, a living will is not a legal document. It's used in other provinces for expressing a person's end-of-life wishes. The legal options available in British Columbia to address healthcare wishes for an end-of-life situation are a representation agreement or an advance directive. To make things just a little bit confusing, there are two different types of representation agreements. So keep in mind that at this point, we're looking at documents for people who are planning for the future. A Section 9 representation agreement requires that the person understand the nature of what is covered in the legal planning document and the consequences of authorizing someone to act on their behalf for health and personal care. A Section 9 representation agreement does not cover legal or financial affairs and does not require a lawyer or notary to create. A free basic representation agreement 9 form is available on the NIDAS website listed on the helpful resource document. It includes a set of instructions on how to complete the form. We're now going to take a look at planning for help now. If the person's capability to understand is in question at the time of making their planning documents, you'll want to consider making a representation agreement section 7, as highlighted in red on this slide. This time we'll talk about Lillian. Lillian can no longer make decisions on her own behalf. Lillian is living at home with her daughter, but she's unable to recognize her granddaughter. Lillian's daughter May and granddaughter Sophia want to know what they can put in place to support Lillian. Because Lillian no longer meets the threshold for legal capacity, the choices are limited to a representation agreement section 7 or comitationship. The Section 7 representation agreement is a legal document that allows an adult whose mental capability is in question to give certain authorities to someone they trust. The Section 7 representation agreement has 4 areas of authority that include major and minor health care, which is making decisions around things like medication, tests, dental care, and minor surgery. Personal care, which can include decisions about living arrangements, making requests for a particular diet, or for types of therapeutic activities. Legal affairs. This authority is significantly more limited than what's available through a full enduring power of attorney, but it can enable the representative to obtain basic legal services or settle an insurance claim. The representative of a Section 7 cannot sell real estate. And finally, the Section 7 agreement includes routine management of financial affairs, which includes things like banking, applying for and managing government benefits, completing and managing income tax assessments, managing investments, or redirecting mail. The Representation Agreement Section 7 does not require notarization nor a legal professional, although consulting with a lawyer or notary is highly recommended. The Section 7 also does not include certain financial authorities, like dealing with real estate or using or obtaining a credit card or line of credit for the person. A free standard form with instructions is available on the NIDAS website that can be used to ensure that the representation agreement being made meets the requirements for a valid legal document. The document needs to be signed in front of witnesses. Comitationship is the least preferred method of dealing with someone's affairs, and it's primarily used in one of 3 situations. No planning was done while a person was legally able to make documents, and now a situation has arisen where decisions need to be made. Or perhaps planning was done, but plans have fallen through. For example, the person appointed as a representative on a representation agreement is no longer willing or able to act. Maybe they've become incapable themselves or have died. And finally, sometimes comitationship may become the only option if family members have different goals or they can't work together as a team or they're in a disagreement. This can happen, for instance, when siblings can't agree about what to do for mom. This is another reason why planning in advance and setting up an enduring power of attorney and a full Section 9 representation agreement is so valuable. It allows you to ensure that your choices are clear for those who are appointed to carry out your wishes. Court process in comitationship involves a great deal of time, money, and paperwork. That said, while comitationship may not be the preferred way to go, it can be tremendously helpful and reassuring to know that in situations where no pre-planning has been done, there's still a safety net available. A family member or friend may apply to the court to be appointed comité of the person for health and personal care, and or comité of the estate for legal, financial, and business affairs. More information on these processes can be obtained from the public guardian and trustee. They have a variety of booklets and resources available on their website. Talking about what kind of long-term care we want, or whether we want to be given CPR and resuscitated, are not the kind of conversations that everyone is comfortable having. But especially if you're living with dementia, they are conversations that need to take place. Our comfort level with these types of topics can vary depending on our age, our experiences, our family backgrounds. All of these factors can play a role. I'm going to show a short but very good video. It's just 4.5 minutes long, and it can be shared as a good way to start the conversation. It discusses why planning conversations are so important.
I would guess there's a big percentage of people don't like to talk about it, and there's a big percentage of people that it happens suddenly, you never get a chance to talk about it.
Well, of course, we are from the age that things weren't talked about.
It's not part of, hey, what'd you have for supper last night?
You've got to know what to do, what you want done.
We have to talk about this. We should talk about it so that when and if this happens, you get the care that you want.
The same day I came in, they told me I had leukemia. You can't see the leukemia going away. My wife and I have talked about pretty well everything.
Well, we did talk when you were in the hospital.
Oh yeah, I guess
And you
so.
did make the decision. We've talked since then and before that a little bit.
What did I decide?
You decided that you didn't want any CPR and that you didn't want resuscitation.
I still think that.
It's very difficult for a family member to make that decision if there's been no discussion. Most of the time we wait too late. We're often in a critical situation when we're asking those questions.
So it is new to us to talk openly about private things. I think it takes a while to get comfortable because it is a privacy thing, eh? Even with your own family. It's not so simple to say what you want or what you don't want.
We're in a situation where we're having to communicate with family members about decisions to either apply or continue or withdraw life-sustaining treatments. Frequently you hear, oh, I don't know what Mom would have wanted. Mom never told me, or Mom never talked to me about this. And so the family then in that acute moment has to struggle with helping us make decisions with what Mom would have wanted. It would have been so much easier had Mom communicated to her family in advance what her wishes, what her preferences, what her values would be.
And 15 years ago, people didn't talk about dying.
They were still going to die.
Yeah, that's true.
I do a lot of interacting with families of critically ill patients because most critically ill patients can't communicate themselves or only minimally. By and large, people are very glad. Their family members are really glad to have this on the table.
The most important person to communicate to is that person who will represent you in the event that you're unwell and not able to speak. My plan or my wishes would be that I would want this, or that I would not want that.
My wife and I have talked about pretty well everything. She knows what I want.
But the main decisions are that you've decided what you would like and not what somebody else would like.
That's right.
Particularly.
That's right. Not a fuss for one thing, not a big flurry.
Yeah, and not a crisis decision.
No.
I'm certainly glad that you and I have had the discussion.
So then the kids can't say to you, what did you do that for?
Exactly. Exactly. And
Well, I didn't do it on my own. The old girls said that.
So, what did you think? Have you had these conversations? Or tried to? What was hard about it? Or what do you anticipate being hard? Let me share an example that a care partner shared with us. Amelie is the youngest child of much older parents. Amelie's mom was 43 when Amelie was born, and her dad was in his 50s. Amelie shared that throughout her life, her folks talked openly with her about what would happen to her if something were to happen with them. Even when she was quite young, they talked about the safety deposit box and where the will was kept, and that her older brother would look after her. Amelie's husband David, in contrast, is the oldest child of very young parents who had all four of their kids before they were 28. Death and dying were not part of his family discussion at all. Amelie told us that during one of the first dinners David had at her parents' home, when Amelie and David were dating, something caught her mom's eye, and in the middle of dinner she said, "Hey, Amelie, when I die, would you like to have the china set?" Well, Amelie's poor boyfriend at the time just about choked on his potatoes. He couldn't imagine having that kind of conversation over dinner. But for Amelie, it was such a part of her landscape that she was able to just consider the question and answer yes or no, and the meal just went on. This dinner discussion really encapsulates how different people's experience with talking about personal planning can be. As we've talked about, for many, having the conversation about personal planning is in itself the biggest barrier to putting in place the tools that we talked about today. Whether you're the care partner or the person living with dementia, it can be hard to start up the conversation. Here are a few examples for opening the discussion about personal planning with your family members. Try framing the conversation as a request for help, such as, "I need your help with something." A person with dementia may already feel scared or worried about the future. Acknowledge the emotions. "I understand that this may be a difficult conversation to have, but here's why we should start to talk about it." Or you might want to share that you are also worried and would like to talk about the future so that you are both more prepared. "Even though I'm okay right now, I'm worried that something might happen, and I want to be prepared. Can we talk about what care we would want if something were to happen?" Another idea is to try opening the conversation by inviting the other person and other family members to share in a planning activity that you've been working on. Something like, "I just answered some questions for what I'd want my end of life to look like. I'd like you to read my answers. What would your answers be to these questions?" Or some caregivers have success by starting the conversation with a specific question. For example, "Mom, if the doctor asked you who you trusted the most to make decisions for you, what would you say?" Some general advice to consider when having a discussion with any professional involved with personal planning, including lawyers, physicians, and case managers. Information and policies are constantly changing. This is why it's important to ask a lot of questions, to find the information you need, and to clarify that the information you have is up to date and accurate. Questions to consider may include, who should I speak to? What does the policy or law say? When can I expect to hear back? Or when should I follow up? What are the next steps? Write down questions as they come to you so you're prepared for meetings or appointments, and try to prioritize questions in order of importance to ensure you get to the ones more important to you in the time that you have. Don't be afraid to speak up if something doesn't sound right to you, or if you don't agree with a decision. It's okay to seek a second opinion. For example, disagreeing with a physician's determination of the person's fitness to drive, or a lawyer's assessment of the person's capacity to make informed decisions. Having a friend or family member accompany you to meetings or appointments as a note taker can allow you to focus on the conversation. Take notes on the content of the conversation, questions that arose, names of who you spoke with, and the date of the conversation. Try to keep all your notes in one place. If an issue arises later on, it will be helpful to have organized notes for reference. Be firm with your concerns or request for information, but stay polite. Acknowledge the efforts made by the other person, even if they are not clear, and ask for clarification until you fully understand the information. Don't be afraid to be honest about how you're feeling, depending on who you're speaking to. When speaking with a lawyer, keep the conversation focused on the facts. And if you're being told that's what it's like for everyone, call a staff member at the Alzheimer's Society of BC to talk about advocacy and avenues for appeal. Your experience is your own, and no one can tell you what your experience is like. In the helpful resources document that's linked below, there are links to these documents that may be helpful. The first two documents are ones we've created to provide some structure for planning. Personal Planning Along the Dementia Journey is a great resource that includes a checklist of important planning areas to consider, and it also includes tips, resources, and suggestions about planning financial and legal affairs and health and personal affairs. The second document, Navigating the System, outlines some of the services provided by health authorities, from home and community care to long-term care. We also produce an annual Guide to Income Tax and Benefits handout, which provides information on some of the tax benefits that people with dementia and caregivers may be eligible for. A link to the webpage with the most recent one is included. In the Helpful Resources document, you'll also find links to a number of different resources on the NIDAS website. NIDAS is a nonprofit organization devoted to personal planning in BC. Their website provides informative resources and sessions on personal planning tools. We also offer an additional workshop specifically on accessing services if you would like more information on the services available to you and how to work with home and community care. You can also follow up with staff on the First Link Dementia Helpline. Personal planning is a very large topic, and we've just touched on some of the pieces. In the Helpful Resources document, you'll see links to other areas to consider and how you might begin to plan for the future as it pertains to those areas. We have recordings on some of these other topics, as well as helpful resources for each. It can feel overwhelming, but don't look at the whole process. It's like the old saying, how do you move a mountain tomorrow? By starting to lift stones today. By focusing on one area, one conversation, you can work your way through the different pieces. The important thing is to start. So I'd like to finish by challenging you to pick one thing and get started on it today. Download the Helpful Resources document and then pick one of the documents from that list to download, read through it, and take the first step. If you have a question about anything dementia related, please don't hesitate to call the First Link Dementia Helpline. Our staff are a great resource to strategize with, answer questions, or even for those times when you just need to talk to someone who understands the dementia journey. This support is available in BC in Punjabi, Hindi, Urdu, Cantonese, and Mandarin, Monday to Friday from 9 a.m. to 4 p.m. Support in English is available in BC Monday to Friday from 9 a.m. to 8 p.m. And in Yukon, the English line is available Monday to Friday, 10 a.m. to 8 p.m. Mountain Time.